Madam Acting Speaker, this bill is a hopelessly confused approach by a panic government that is acting like a rabbit in the spotlight. It is not a product of any rational public policy at all. Now, in saying what I say, I adopt the reasoning and views of the Shadow Attorney-General and Member for Liverpool. And I have to say that for the government to react and panic as it has in rushing in this bill shortly after it enacted the principal legislation in the 2013 bill, is just extraordinary. You know, a number of months ago, there was a new Attorney-General in town. In fact, in an article published by Sean Nichols only last Saturday, titled "Ambitious Attorney-General Brad Hazzard Promised a Breath of Fresh Air in New South Wales and the Law and Order Debate." Well, this is not a fresh air. And of course, last week, the Attorney-General declared at a luncheon organised by the McKell Institute there was, quote, a new Attorney-General in town. And of course, there have been a number of words espoused by the Attorney-General since his elevation to that high office, or appointment to that high office, which is the words you would expect of an Attorney-General of the state, words that have been missing from a number of his predecessors. But as an old Irish friend of mine, who's actually the president of the local soccer club, I tell the member for Wallsend, says to me, paper never refuses print. They are only words. And of course, one of the observations that Mr Nichols makes in his story was this. Let's not forget that Hazzard's predecessor, Smith, began in the portfolio in a similar fashion and was eventually eaten alive by the reactionary media and ultimately his own cabinet, who did not share his stomach for the fight. Well, the Honourable Greg Smith, SC, at least lasted 3.5 years or so, or 3 years before he was eaten alive. The new Attorney-General in town lasted about 3 weeks before he collapsed under the pressure of the reactionary broadcasters. And I've got to say this about the reactionary broadcasters and why they are dangerous in terms of panicking and overreacting based upon their views. The reactionary broadcasters are salesmen of advertising. They're not commentators on public policy. They are selling advertising, and they do so extraordinarily successfully. And in areas like this, they prey to the people's fears and prejudices. And in a climate of terrorists, they play to their prejudices. And they're playing to a panicked government who is running around like a rabbit in the spotlight, not knowing what decision to make as its crossbench gets bigger and bigger and bigger, as allegations of corruption continually get made, looking somehow or other to curry favour somewhere. And in so doing, you forget the whole premise of public policy. Now, the Attorney-General of this state, I have said in this House, and I have said to him privately, I have been encouraging him to take the views that the Attorney-General should take. But this is contrary to everything that the Attorney has been saying. So let's remember what the purpose of bail is. And let's remember that anybody charged with an offence is entitled to the presumption of innocence. And the title of and the words presumption of innocence are not meaningless phrases. We stand in this House, having the privilege of being members of this House, being the oldest parliament in the country, that maintains traditions and maintains respect for those traditions, constitutional traditions and the common law. Yesterday we were reminded at the joint sittings that the sovereign and the sovereign's representative is not permitted in this House because 371 years ago King Charles tried to force his way into the House of Commons. And it is our function, it was our function yesterday and it is today, to maintain traditions, to maintain the constitutional traditions and to maintain the common law that has been developed over hundreds of years to protect our citizens. It is our job as their representatives. And the purpose of bail The purpose of bail, when it infringes against the presumption of innocence and detains someone, is to ensure, bail is to ensure, one, guarantee people's attendance before the court. That's what its purpose is. And you take away their liberty when you need to protect the community, either through an accused committing further offences on bail, to protect witnesses or the integrity of the court process, to protect victims who may be threatened or injured as a result of the release. Now, in 1978, when this Parliament intruded and sought to codify the Bail Act, it created a series of problems. Just whenever this Parliament intrudes, even if it intrudes rationally after careful consideration by the law enforcement, by say the Law Reform Commission, there are always unintended consequences. So the problem started in 1978, and the legislature kept changing the 1978 bill till it became absolutely unworkable. Until 2010, when the then Attorney General, quite controversially, released a proposed bill that provided for no presumption in favour of bail. That was considerably controversial, and some might think quite reactionary for a Labor Attorney General. And I could just imagine members of the government of the day, even in the Law and Order auction of 2010, would have been quite concerned about that bill. Now, on the election of the O'Farrell government and the appointment of Smith Senior Counsel as Attorney General, a highly respected senior counsel, that bill was referred to the Law Reform Commission, who considered the matter for quite some time before it reported. The Law Reform Commission's recommendations were not adopted because the police didn't agree. The bill that was adopted in 2003 was actually the view of the police as to how bail should operate. The opposition cautioned in 2003, last year, in respect of the 2013 bill, that there were concerns, but we did not oppose the government at the time, but we said that there will be difficulties in relation to the issue. The bill gets introduced, and within 2 or 3 weeks, the government is in panic mode as a result of a couple of decisions. Well, the Attorney General of the day never referred to how many hundreds and hundreds of decisions are made in respect of the Bail Act every week, and I think 2 were raised by the reactionary broadcasters and by the popular press. In respect of those 2, one of them was rectified by the Supreme Court by Justice Hidden. So instead of doing what any other rational, sane government would do that had some intestinal fortitude, you might see how it plays out. You might wait for some of the decisions of the Supreme Court to see whether this legislation, 3 years in the making, was actually going to work over a period of time. But did the government do that? No, the government just tried to appease the popular press in an effort to say it was going to make amendments. And can I tell you, from the time the government ran around and panicked and said they were going to make changes, to today when it's introduced the bill and is debating the bill now, where are these other raft of bad decisions being made? Where are the cases? Where are the judgments? Where are the critiques of hundreds of them occurring throughout the state? Where your own bill you adopted last year, where we said there would be problems, is causing a massive or major problem, or is it only the one isolated issue? Now, in relation to your approach with these amendments, I just want to highlight several issues of concern in respect of it. As I said, the opposition does not oppose the bill. You're the government of the day. It's your function to govern. This is your bill. We just say to you again and put on the record that this hopelessly confused approach will create significant problems. Madam Speaker, Acting Speaker, I might have an extension of time.
The question is that an extension of time be given. All of that opinion say aye. Against, no. I think the ayes have it. The ayes have it.
I want to say that I want to express my considerable concern about the common law presumption of innocence. That is, that the right to be at liberty is removed from Section 3 and placed in a preamble, together with the principles relating to the integrity of the justice system and victims and community safety. And when the Attorney General, the new man in town, the new sheriff in town, or the new attorney in town comes back in reply, he might give an intellectual basis for doing that, and not just read some words written out by people from his department or his office. The bill also, as I indicated at the beginning, relates to a hopelessly confused approach by a government who continually changes its position. The changes have been introduced without any attempt at proper statistical analysis. It's a chaotic approach. It imposes presumptions which I would suggest to the House are inconsistent with their own risk assessment model that they implemented in the 2013 bill. It imposes presumptions for some offences but not others, which will repeat the very inconsistency of the previous bail legislation. And as has been pointed out to me in respect of the bill too, the show cause provision, which shifts the onus of proof for people who have not been convicted of any offence. The Shadow Attorney General points out 57.3 of those people refused bail in magistrates' courts do not receive a custodial sentence. And he suggests, and I agree, that these are backdoor ways of reintroducing presumptions, which was the reason that the 1978 Act was so criticised. And more importantly and significantly, and this is something the Attorney General needs to consider when he comes back in again, because this is part of the unintended consequence, and it was referred to by the Shadow Attorney General towards the end of his second reading speech, when he suggested that presumptions are arbitrary and focus on the categories of offence rather than the actual facts of the case. And he used as an example a female victim of domestic violence who strikes back and an attacker would have the onus of proof of bail reversed against her if it had happened before or she had given the attacker a split lip. And once you start imposing these sort of provisions with uninformed consequences, the result is all you're going to do is penalise people of a particular category. These matters need to be determined on a factual basis. They do not need to be determined simply in an arbitrary, statutory, formulaic way. You need to, and the Attorney General will say this, but it should apply in the Act, the Parliament needs to trust the judiciary and the judicial process in the administration of law and rely on the appellate process to rectify any errors or perceived errors. As the Shadow Attorney said, the opposition does not oppose this convoluted, dreadful bill, but it is bad public policy. It's bad public policy created by a panicked government trying to curry favour with a reactionary media.